Now, nearly 9/10 of the UAE population is made up of expatriates, all of whom are here to work, all of whom must have a residency visa and employment contract that needs to follow local labor laws.
For many, there's confusion over the exact nature of those laws, in whether employees can change jobs or not, and how regularly, or whether employers can hold onto their passports.
Well, as part of our ongoing Ask the Expert series, we're getting answers to the most common employment questions that rattle workers here in the UAE.
So here to fill in the gaps is Ivor McGettigan, an employment law expert and senior associate at Tamimi Company. Ivor, thanks for stopping by tonight.
Thanks for having me.
Great to have you. Well, I want to begin by asking you about end-of-service gratuity. Tell me, how exactly is it calculated? Because it's different if you're in somewhere like the DIFC to other parts of the country. And can an employer ever withhold or even reduce some of the gratuity?
The end-of-service gratuity is a payment that non-national employees are entitled to upon termination of employment, and it's calculated on the basic pay only component of the salary. So most employees have a salary, 60% of which is normally basic, and the remaining would be allowances. So end-of-service gratuity is calculated only on the 60%, not the 100, and it's calculated on the basis of 21 calendar days service per year for each of the first 5 years of service, and then 30 days per year thereafter. So there are situations where an employer can withhold the end-of-service gratuity, or an employee can forfeit the end-of-service gratuity. One of those situations is where an employee is dismissed for gross misconduct. In that situation, there's no end-of-service gratuity payable. Likewise, if an employee resigns with less than 5 years service, if the employee is on a limited term contract, then he forfeits the end of service. If he's on an unlimited term contract, then there's a sliding scale of reductions to that end of service gratuity.
Because it's typically about a third then, isn't it? If
if the employee is between 1 year service and 3 year service, he gets 1/3 of the end of service. If he's got between 3 and 5 years, 2/3. After 5 years, the full whack. Yeah.
Read the fine print.
Absolutely.
Exactly.
All right. So, saying someone does have a claim to file against their company, is it something where employment law, is it federal? Is it Emirate based? Where should they be filing these claims?
The labour law is a federal law, so it applies throughout all 7 Emirates. It's at a process level. There's a Ministry of Labour office in each emirate. So, to file a claim against your employer, then you would need to file it in the Ministry of Labour office where that employer is located.
Okay, so for example, if I'm working in Dubai but my employer is Abu Dhabi, it means even though I'm here in Dubai, I've got to go to Abu Dhabi because
Correct.
that's where it is. Okay, what about in terms of if you want to change jobs but you've got maybe 3 to 6 months notice period, are you always required to fill out that much notice? Because what if the job's then not available?
Yeah, so if the employee resigns and doesn't serve their notice period, then the employer can seek compensation from the employee, compensation in lieu of notice. And if the employee is on an unlimited term contract, so an indefinite contract, then the employer can seek the full amount of the notice period. So if it's a 3-month notice period in the contract, then the employer can seek 3 months' salary from the employee for not working through his notice period. If he's on a limited term contract, which is a contract with a shorter term and a definite end date, then the compensation is capped at 6 weeks' salary in that situation.
Okay. Another point, I know that it comes up a lot. It seems to be a bit of a gray area for people, although I think the law is quite clear on it. The idea of that an employer can hold the employees' passports. Where do we stand there?
No, employers cannot withhold or hold on to an employee's passport. And the Ministry of Labour has made this situation crystal clear. And the Ministry will impose fines on employers who withhold employees' passports.
And yet we know it still goes on.
Yeah, absolutely.
It does go on. There's anecdotal evidence that it goes on in a quite a widespread basis, particularly if employees are handling cash. A lot of employers will insist that they hold on to their passports in case the employee leaves the country.
I mean, even for a lot of people who might be labourers or maids or nannies who are not on a lot of money, who don't necessarily, I guess, have a lot of confidence in their ability to be able to challenge their employer.
Yeah.
How do you go about that?
It's an unsavoury practice that has continued, and I think it's starting to phase out now. Ultimately,
You really think it's starting to phase out now?
I think so. From our experience, it seems to be happening less so than heretofore. But from the point of view of what does the employee do, obviously the employee doesn't necessarily want to create a fuss with their employer and create acrimony. But the employee really should say, I understand that I don't have to give you my passport. I understand that is the position. And in fact, what a lot of employees may not realise is the passport is not their property. Your passport is the property of the Ministry of Foreign Affairs of the country that issues the passport. So I have a passport, I don't own it. I have possession of it. And my country will say that I cannot hand over my passport to an employer. So the employee could use that approach with their employer and say that
who should they then, it's in a situation where they've given the passport for visa, sort of applications, for example, and they're not getting it back. What should they do in that case? Who should they turn to?
Well, I suppose the nuclear button is they can turn to the Ministry of Labour and lodge a complaint. The ministry will take it seriously, and they could impose a fine of 20,000 dirham on the employer. The downside of that, of course, is that the employer might react very badly to that and could terminate the employee. So that would be a problem. He may not say that the termination is linked to the event, but that's obviously a risk. So if you can try and do it with some consensus, or the other alternative is if the employer has your passport, just say, I'm going to Oman for the weekend, I need my passport. Then you have it back, and don't give it back, and do what we said, just hold on to it and explain
I mean, is it grounds to lodge a case to say that I've been terminated unlawfully if they do get
Absolutely,
rid of you?
it is grounds to.
Do you literally march into the ministry, or how do you go about this,
Yeah,
this process?
so in relation to any termination, the rules here say that the event that the employer is saying resulted in the termination has to be an event like the performance or misconduct of the employee in their workplace. An employee not agreeing to hand over the passport clearly isn't misconduct. So there would be a very good chance that the employee would be successful in an unfair dismissal claim against the employer. But ultimately, if the employee doesn't want to get into a situation where they have to bring a claim against their employer, then they might consider these other ways to get the passport back.
Can an employee change jobs after only 1 year? I mean, it's something as well we've seen a lot of.
Yeah. If an employee has less than 2 years service and he moves job, he's at risk of being subject to a labour ban from the Ministry of Labour. That's if he's working in a non-free zone environment. So if he's working, we say, onshore, then he has that risk of being subject to a ban. And if he's on the ban could be 6 months or 12 months, depending on whether he's on a limited term contract or an unlimited term contract. There are exceptions to the ban. Firstly, if the employer consents to the employee leaving, there's no ban. If the employer has breached the obligations to the employee, so if the employer hasn't paid salary for a month or has treated the employee unfairly in some way and it was a breach of contract, then there won't be a ban applied. And there's another ground where the employee has certain academic qualifications and he's been offered a new job with a new employer, and that employer has offered to pay the employee a particular salary band. Then in those situations, there's no ban.
Okay. Final question, because we're almost out of time. If your employer has stopped paying you, maybe you've already left and you haven't been paid your flights or gratuity, how do you go about getting that money back? Is it straight to court?
Yeah, so the first step, I suppose, is to avoid a lengthy court process, is talk to the employer, talk to the HR department, and try and sort it out directly. If that doesn't work, then you would need to file a complaint with the Ministry of Labour. And the first step of that process then is the ministry would conduct a mediation type hearing. So they would call the employer and ask the employer to send a representative along to the meeting, and the employee would be in the meeting, and there would be an official from the ministry. So there'd be 3 people in the meeting, and the ministry official would try and broker a deal and try and settle the matter at that stage. If the employer has got legal advice and he realises the claim is one he's likely going to lose anyway, then it's an opportunity for him to settle at that point.
Okay.
But if it doesn't settle at that point, then the ministry official will issue a letter to the employee to allow the employee issue a case in the Labour Court to start an official case. So it's a final, that Ministry of Labour meeting is a final chance to try and settle it before you enter the court arena.
So it's certainly worth doing. There's lots to talk about. We'll have to get you back on the show.
I'd be delighted to come back.